Hi all, welcome to Wednesday Wellbeing Lunch. Today is an expert to do with financial planning in terms of your wills, testaments, inheritance, disinheritance, and all those things that you need to be planning for. So firstly, welcome. If we can be sure that cameras and microphones are please muted, it helps with streaming. This is a recorded session. But you'll notice there is a chat box. Please do utilise the chat box to introduce yourself and to ask any questions. We will be having the question session towards the end. You will notice the screen in front of you is our virtual wellbeing model. This is what we've used as our organisation to enlighten our staff into wellbeing as a holistic approach. You'll realise that today is more about financial wellbeing. These are our webinars. So my name's Carla. I've been working for the NHS for 15 years, and throughout the whole of 15 years, I've been people focused, passionate about wellbeing, passionate about people, and more importantly, let's help get the most out of our wage slips every month. We have done more than one webinar. This is the third. If you'd like to know anything more about the others, there will be some questions and some guides towards the end, but they will cover all elements of your financial wellbeing. So today I'm joined by Dr. David Matthew, who's going to manage our chat room. Hi, David.
Hello, Carla. Thank you.
You're welcome. And our expert is, so Rebecca, can I just take the next slide? Here's Rebecca. And you'll see on that screen that they come very well recommended. They really are experts. And on that note, I'm going to introduce you to Rebecca and allow her to introduce herself. So over to you, Rebecca.
Rebecca, you're on mute.
Let me unmute Rebecca 1 second. Rebecca, we can't hear you. Rebecca, can you hear us?
I can hear you, yes.
Oh, okay, right, we can hear you now. Wonderful. Okay, lovely. Over to you, Rebecca.
Yeah, okay, so my name is Rebecca Huscroft, and I'm going to be taking you through today's wellbeing webinar, which is estate and legacy planning. Today is all about information and raising awareness on some really important key issues based on our personal experience, issues that face many, many families. So we just want to highlight those issues for you today. So what are we going to be covering? Well, the bullet points there summarise it. So avoiding paying unnecessary tax, control over when and how your money is actually passed on, free government wills, gifting money or property to family, which is a really big one, dangers of old out-of-date wills, and the impact of divorce and separation on inheritance, and can your will be challenged, the risk of disinheritance, and why use trust. And we've also got some great top tips to take away today to have a think about with your family and have a chat and think about what's right for you moving forwards. So what I have to do now is just to formally introduce myself. So on the left-hand side is Eulogie. Eulogie are awareness and educational seminar presenters. And for the last 16 years, we've provided seminars directly to the NHS, covering really important key issues on financial and estate planning matters. And on the right-hand side is iForm. iForm is my business, and for the last 17 years, I've specialised purely in estate planning services. And I'm really passionate about helping people protect the really important people in their lives and their hard-earned assets. And through my strategic partnership with Apollo Man Group and Total Wealth Planning Legal Services and my colleague Julia Langford, we provide great support services. Some legal bits I just need to go through with you before we start. So any information that you hear or see today is based purely on the current tax law, and of course it's subject to change and is as accurate as possible. And we're going to go through some really great scenarios today, which based on my personal experience cover the kind of things that people go through day to day, but this is just to highlight and illustrate a point. This shouldn't be taken or construed as advice. So we are all human, and the current situation with COVID, it's a really, really serious situation. And there's a lot of fear and anxiety out there at the moment. And we've actually seen a 75% increase in the number of inquiries, people really concerned about what happens if they're ill, what happens if they have to go into hospital. And so we put this slide in just to highlight that and say that we want to reassure people, and we don't want to see people making decisions based out of fear and anxiety. They should be great decisions made in the right time that's right for you and your family. Okay, so today's focus of the webinar is going to be wills and estate planning. So what is estate planning? It all sounds very grand. I just want to talk you through now, what are the parts? What is that made up of? So wills, trusts, lasting power of attorney, funeral planning and probate are in the main areas that we're going to focus on. This is just one of a suite of 6 different webinars hosted by my colleague Neil Houchin, covering financial matters, really important key issues. So he's going to be covering some of those areas there on the other webinars. So we're both experts in our own field, but today is specifically about estate planning. We're going to start by looking at taxation. Taxation gains tax. So whilst somebody is alive, what happens on any profits that they realise? And the reason that we put this slide in here is simply because we see more and more people now owning second properties. So either through inherited means or because they purchased them, simply just to give them some extra income in retirement. So it's a really popular thing and a really common an inquiry that we have. So anybody that does have a second property, potentially when they sell it, if they make a profit, could have a capital gains tax liability. And increasingly, we're seeing more and more people come forward that are totally unaware that they have a liability. So we just want to raise this with you. And again, to help people avoid paying unnecessary tax. So lots of options in this area, but it's really, really complex. And I want to stress is the importance of getting information in advance and knowing the facts and avoiding paying thousands of pounds in tax. So one area that we see all too often is people being added to property. For example, to avoid paying for care fees, son or daughter could be added to mum or dad's property. Really, really popular thing to do. However, that then makes them a co-owner of a property. And if they've got a home themselves, when they come to sell that property, they may well have a capital gains tax liability. And word of caution, so from the 6th of April this year, HMRC have unfortunately made a really, really big change to the way that they want you to report and pay capital gains tax. So that anybody now that's completed on the sale of a property after that particular date will have to pay capital gains tax within 30 days. So change, and we don't want to see people get caught out by that. So here's my first top tip. So top tip number 1 is to, if you have a second property, really important that you keep really good records. So record the date it was purchased or the date that the property was inherited, and the same with the price. So how much was the purchase price of the property, or of course if it was inherited, what was the value, and what's the value now? And of course, if there is any kind of gain there, please be mindful that you could end up inadvertently with a capital gains tax liability. The next few slides are dedicated to inheritance tax. Inheritance tax is fundamentally part of what we do here. We don't want to see people pay unnecessary tax, and this is often referred to as a voluntary tax. But with £5.4 billion having been paid to the revenue in the previous tax year, it's an enormous amount of money that's going not to people's families or beneficiaries, it's going to the revenue. So again, you have options, but again, this is a complicated field. And if you do undertake any planning or go for advice, make sure that the person is suitably qualified. We see a lot of DIY disasters in this area. And again, today is about raising and highlighting those areas just so that you don't fall foul to those. So potentially people that do make mistakes in this area could end up losing their own property. So those 2 areas, 2 biggest areas are gift with reservation of benefit, this one here. And the first one, just people often want to solve one problem but create another. So they will gift away a property but then continue to live there and unfortunately have no impact for inheritance tax. There are strict conditions and rules. if somebody does want to gift away property, how and when that should be done. And deliberate deprivation of assets, again, we see a lot of people gifting away property in later life. And unfortunately, if that person does need care in the future, a means test would obviously have to happen with the local authority. And should that happen, the person has given, then potentially the local authority could have deemed them deliberately to avoid care. So again, unintended consequences there, and we want to help people avoid that. So my top tip number 2, if you have some time, please write down these kind of figures. So everything you own, so your estate, it all sounds very grand, but your estate is everything that you own. So really great idea, just to get an idea of what the value of your estate actually looks like. So writing down all of your assets, property, savings, investments, that kind of thing, and their values, and then including all debts. So the 2 taken away is your net estate value. So that will give you an idea. If it exceeds the thresholds, which we'll look at in a moment, potentially you could, or your beneficiaries, of course, could have a liability. This is a really, really big hot potato, this one. So a lot of people try and do DIYing here. So they try and deal with the problem of reducing their own inheritance or their family's inheritance tax liability. So the kind of things that they will do is gift away, and you can gift away any amount of money that you want, and it's entirely up to you. However, if you gift away money or property in excess of these values here, and these are just some of the allowances, potentially they could fall back into your estate and become taxable if you don't live for 7 years. So again, a really important one here. We see a lot of people trying to give away money and it fails. And ultimately, people then end up paying more tax than necessary. So please beware, HMRC do have a 14-year rule. Again, it's complicated, so if in doubt, please ask and take advice and get information. But potentially, we can go back 14 years. So my top tip number 3, again, anybody that wants to gift away money and wants to do so with a view that they feel that they no longer need those assets, or they want to start looking at some inheritance tax planning, really great idea to write down any gifts that have been made in the last 14 years. So please record the date, so the date that the gift was physically made, the amount and the recipient, the person. And it's really crucial to keep hold of those records, because at some point they will be needed and will be called upon by HMRC potentially. So what happens when somebody passes away? So the lifetime gifting that we've just previously looked at then becomes a position on death. So in the table there, we've got the top allowance, the personal IHT. IHT is inheritance tax, single and married couple. So we can see there clearly that the married couple gets a doubling of the allowance, so 325 becomes 650, that can be passed on to intended beneficiaries without any inheritance tax being paid. So that's a standard and automatic allowance. Don't need to do anything, it's automatically applied, and it's been there for a long, long, long time. But back in 2017, a new allowance was introduced, which sits in addition to the basic personal allowance, the standard allowance shown above, and that's the property allowance. And for those of you who've worked it out, that in effect gives us a golden number of £1 million. So much excitement around this. A lot of people would assume now that they will be able to pass on £1 million without any tax implications. And yes, absolutely, some people will, but caveat here, there are really strict rules and strict criteria that must be adhered to. So the estate must, in the first instance, qualify. So, for example, the estate must be passed on to direct descendants, so shown here in the red text. So not everybody, not every recipient of this will qualify along with the rules, but the size of the estate and timing and everything else is really, really critical. So there are lots of things that can go wrong, and unfortunately we see far too many people missing out on this great new allowance, and so it's not automatic, and executors would need to apply for it. So it's not just a freebie of £1 million passing. It sounds an enormous amount of money, but parents, baby boomers now, have amassed property in their estates, and we're seeing an increasing amount of people who have estates around and about those figures. So a really great one to have a think about in advance. So anything in excess is charged at 40%. So it's a really hefty tax. And again, you have options and choices. Just a high level overview to raise awareness on these issues. So right at the bottom here, does your will contain a trust? So prior to 2007, it was really, really commonplace and popular to include a trust within wills, and a lot of people did it, and we continue to see a lot of those old will trusts coming forward. And unfortunately, the terms and conditions of the new property allowance mean that certain types of trusts will automatically not qualify. So inadvertently here, people are losing entitlement to allowance, and it's too late simply because the trust is included within. So we don't want to see people in that situation. So my next top tip 4 is locate your will. If you have a will, please dig it out and have a really good read through it. There will be lots of legal jargon in there, but parts of it will of course make sense. Have a look at executors and relationships and people that are named in there. Are they still alive? Do you still like them? Are they still relevant in your life? Do you still want them to benefit or be involved? And importantly, does it contain any trust clause, any trust wording? And if you're at all in doubt, please ask, please come forward. We'd be more than happy to provide a will review, and which will ascertain whether or not that would contravene the new rules and prevent your executors making that application when you're gone. Release, really increasingly popular and common these days. About £4 billion was released through lifetime mortgages and such like last year. So it's becoming a really commonplace part of financial planning. And it's something that we want to raise as part of today's webinar, because often people use equity release to reduce the impact of inheritance tax and the implications that can have. And also people want to approach retirement and think about helping maybe their children and grandchildren get on the property ladder, and also making updates to their property, going on a cruise, whatever it might be. There is certainly a great option now for people to consider about using the value in their property to release during their lifetime. And some great safeguards and measures for anyone that's worried about equity release, meaning that you won't pass anything on to children and grandchildren. So features and controls such as a no negative equity guarantee can be placed on these kind of lifetime mortgages to ensure no matter what happens, there's always something left over for children and grandchildren. But also drawdown facilities as well. So effectively treating the pot like a drawdown facility. So again, a way to reduce charges and make it really cost effective to help supplement any kind of income or capital in your retirement. So my top tip 5, my colleague Neil also alluded to this in his financial awareness seminars that he's run, and that is to keep a close eye on what's coming in and what's going out, just so you know what your requirements are, and therefore you can tailor your own personal situation to your current situation. So recording what's coming in, what's going out, and also any big planned expenditure. And that will then tell you if there's any need for extra income or capital in your retirement. Okay, so we're now going to focus back on specifically estate planning. So trusts, for anyone that knows a little bit about trusts, so they've been around since medieval times, they're not new. They are there as the gold standard. They are there to provide security, control and protection for generations. So this is where legacy planning comes in, creating a legacy for somebody for generations. Life is incredibly uncertain, especially given COVID in the current situation, and people have concerns and anxiety about protecting their hard-earned money for the people they care about, and are conscious that things can come along during lifetime that could threaten that. Funeral plans have become increasingly popular in the last few years. So prepaid funeral plan is simply paying in advance for your funeral. And with costs increasing of about 8% a year, the great thing with these funeral plans is that you are locking out inflation. You are effectively securing the cost at today's price, but also, really importantly, making it very easy for your loved ones. So when the time comes, it's simply a phone call and everything's organised. So they're really, really great thing to have. Again, word of caution, lots of companies out there doing it. Just be careful about doing some research and making sure that you've got the right company. Okay, wills. Wills are, of course, a central feature. So just simply a set of legal instructions explaining who gets what and when. Probate is the legal change of ownership. So when somebody passes away, generally assets in excess of about £25,000 will have to go through probate, which is just the legal change of ownership from the deceased to the living. And that can be done yourself or through a professional. And then finally, power of attorney, which for me, personally, based on my years of experience, is the single best and biggest thing you can do to protect yourself and your loved ones during your lifetime. Power of attorney enables you during life to protect yourself and appoint people that you trust to make those big important decisions, or just the simple things. If temporarily you're ill, so you have to go into hospital, or you have an accident. So you're handing the reins to the people that you trust, so you're in control. And I just want to stress this, it really is about keeping control. A lot of people are concerned that having a power of attorney means losing control. Now on wills. So a will, as I've just previously said, is a really important legal document, but it simply sets down a set of clear instructions as to what should happen when you're gone. So who gets what and when, and your executors are there to manage that for you and ensure that your wishes are upheld. So a will is peace of mind, and it's not there for you, it's there for the people that you leave behind. So who needs a will? All of those people listed there, plus many more, do of course need a will. Everybody needs a will. So I'd just like to highlight that partners, anybody that has a partner, the law does not recognise that. There's no such thing as partner or next of kin when it comes to inheritance. And unfortunately, we see an awful lot of people who are in a partnership who don't have a will, who are locked out and who don't inherit, and it's a very sad and avoidable situation. Divorced people, anyone who's divorced or separated, again, red flag here. Ex-spouses, partners named in wills, especially for divorce. The government has a standard will for you, which we're going to have a look at in a moment. But essentially, anybody in that situation could end up dying what we call intestate. So if they don't have, if they've got a will and an ex-spouse is still named, potentially that could just be cancelled out and treated as if they died without having any will at all. So really important, anyone that's divorced or separated, to dig out the will and make sure that the changes are made. Children, really, really important. Anyone that has children below the age of 18, a will allow you to appoint trusted people or legal guardians to look after your precious children if you're not here, up until the age of 18. You can put conditions on there as well, so really important. Please don't just assume that children automatically go to your choice of person. They've of course got to go through balances and checks and ensure that they are safe, of course, to go to those places. So we often, unfortunately, see children temporarily go into care. We want to really help people avoid that situation. So here's the free government wills that I alluded to initially. So for anyone that likes a freebie, you may or may not like this one, but I suspect you probably won't. So for anyone that dies without a will, and apparently only 40 to 50% of people do have a will, so we're trying really hard to work on that and improve on that. But for someone that doesn't have a will, there has to be some rules, and therefore the government has got a will for your beneficiaries, the people in your life, and they've created the terms and conditions of that. And so we put this together as tongue in cheek, but essentially these are the kind of things that happen. So to my family, I hereby leave you several months, possibly years of financial hardship and expense. I sort out the mess, and so a lot of delays and unnecessary expense while things are unpicked and the estate is sorted out. To my spouse or partner, I hereby leave you some, but probably not all of what I own. To my children, I hereby leave you the remainder of my estate and give you the authority to enforce the sale of the property, including the family home, to realise your inheritance. We see lots and lots of delays and people that have not left a will. So again, really important if you really want to protect those people you leave behind. And social services, we've just covered there. If my children are orphaned, I give you the authority of guardianship and the power to choose who should look after them, including allocating them to foster parents. The taxman always wants his fair share, so I hereby give you all the tax that I could have avoided and given to my family. To my bank and or solicitor, of course, they may want their fair share. I hereby authorise you to charge whatever you feel necessary to sort out the mess that I have left behind, and realise that this could make you one of the major beneficiaries of my estate. Really, really big flag here. Anyone that has a will, please dig it out. Is a bank or solicitor named as executor? So a lot of free wills that are given out, word of warning here, things generally aren't free. So often a bank or solicitor have written themselves in as executor, and then almost it's a blank check. What are they going to charge? So we see all too many people paying 4 and 5% of the value of the estate in legal fees, and that's obviously less going to the family. To everyone else, I leave you nothing. So that's all of the relatives, friends, charities, anyone that's important to you effectively really is at the last line of the queue. So now I want to look at home ownership. Our homes are generally our biggest assets, and we are property mad in this country. We do love our homes. And so how do we own our property? So a question to everybody listening: how do you own your own property? Is it jointly? So is it you and somebody else that lives in the property, or is it tenants in common? And tenants in common is becoming increasingly well known, and for good reason. So tenants in common means that if you live with somebody else, you own that property as a percentage. And usually if it's two people, it's 50-50. If it's a jointly owned property, which is the traditional way to own a property, it means that if there are two people, they each own 50%. And when one of them passes away, it automatically passes to the survivor on first death. Have a look at some scenarios. So I said initially, these scenarios are based on my 17 years of experience. These are the kind of things we see day to day, and we just want to bring this to your attention to help raise awareness of the kind of things that can happen to help you avoid these common traps. So in this scenario here, we've got partner A and partner B, and they've got 2 children, and they own the house jointly. And for most people, they believe that this is a good thing, but we're now going to have a look at why that isn't a good thing. So if B needed to, so if partner A dies, everything passes through the laws of survivorship to partner B. If down the line then partner B decided to meet somebody else and remarry, the existing will that they had, so partner A and partner B, everything is cancelled out and it's revoked. And let's assume that they're now wedded to the title, and therefore everything passes to the spouse and disinherits partner A and partner B's children. But if partner B then had to go into care at some point in their life, they would also be subject to a means test. And again, this is a really big area and a big red flag. Anyone with assets over 23,250, which is most people, including property, will be deemed liable to pay for their own cost of care. And this is the point where people, unfortunately, are forced into selling their property to fund their own care costs. So hopefully by raising awareness in this way, we can help highlight this. So we're now going to look in a pictorial form. So we've got the same scenario here. So we've got partner A and partner B. Partner A, because the property is owned jointly, everything passes across to partner B, who then becomes the sole owner of the house. A few years down the line, partner B decides to move on and they meet somebody else and marry to partner C. And partner B, unfortunately, dies. And what happens then? So because everything then was jointly held, partner C then becomes the new owner of the property. And partner A and B's children are completely cut out of this because everything through the laws of survivorship, because it was simply a jointly owned property, passes to the new spouse. And of course, if partner C had children, they could potentially inherit too. Situation here, just to re-emphasize that same point. So what if there is a will? So let's have a look at that. So marriage revokes or cancels out a will. So somebody remarries, meaning any instructions previously that were written down, no matter how good, were invalid. So that has a big impact. And cohabiting with a new partner also will have an impact and create complications for the existing and new situation. So again, we've got some unintended consequences that A and B could be subjected to. So A and B's children disinherited, and of course any other intended beneficiaries missing out too. And of course care fees could become applicable, so that jointly owned property that A and B currently own could end up being lost through unintended consequences such as that. Okay, so I just want to share another scenario with you now, which is becoming increasingly commonplace and something we see on a frequent basis. So people now often remarry. They may have stepchildren, they may come together and have children together, and that creates some different challenges and some complexities when it comes to protecting the bloodline and estate planning. So in this scenario here, we've got Mr. who owns his own home. He's got some savings and investments, but he's also got two children in a previous relationship. So he meets a partner, and she is in exactly the same situation. She has assets in her own name. So she's got the property, she's also got savings and investments, and she's got children from a previous relationship. So they come together, they marry, but they decide that they feel it's best to maintain their individual assets in their own names. They feel that's right for them. And they also think that it's sensible to go off and write some wills to ensure that they are protected. And they feel that a standard mirror will is the right thing for them. So what happens when Mr. passes away? Everything passes to the survivor, because the mirror will clearly stipulates that on either one of their deaths, the surviving spouse to be the priority. So it's a mirror and everything goes across. So these are really commonplace, typical wills that we see. So even though there are stepchildren, as a first priority, the surviving spouse, Mrs. in this case, becomes the sole beneficiary. But unfortunately, Mrs. has had some fallouts with her stepchildren and decides that actually she wants to prioritise her children. So she rewrites a will, and of course she's absolutely within her rights to be able to do that. So she writes a new will in favour of her children, disinheriting her stepchildren, so that when she passes away, all of her assets and that of the deceased spouse passes down directly to her bloodline. And that means that her stepchildren, the deceased spouse, the first spouse's children, don't receive a penny and are completely disinherited. So the issue here is simply that a mirror will is a problem. So I just want to highlight that jointly owned assets are an issue, as are mirror wills, and it's really important to understand what can happen for anybody that has a family like this. And we've got a similar scenario here. So again, somebody is going to a second marriage and has stepchildren. So same scenario, Mr. has his own property, cash and investments, and children from a previous, as does the person that he now meets and decides to marry. But this time, rather than keeping assets in their own names, they decide to pool all of their assets together, and they feel that that's the right thing for them to do, and they establish standard mirror wills again, because they feel that that's the right thing to do. So the mirror will stipulate that the survivor of the two of them, so the surviving spouse, gets everything on first go, and then it passes down the generational line to their children. So the same scenario occurs when Mr. passes away, everything goes to the survivor, Mrs., and of course she can rewrite her will in favour of her own children. So the same situation happens on second death. The stepchildren are disinherited and the bloodline is not protected. Same issue here. So it doesn't matter whether it's jointly owned assets or pooled assets, zero protection if there's just a standard basic mirror will. What's the solution? A few slides ago we spoke about tenants in common. So owning a property through equity division or equity percentage. So in this situation here, partner A owns 50% and partner B owns 50%, which is a typical scenario. And partner A and B then go off and create new individual wills themselves, and they can be a mirror of each other, but they are individual wills. But the difference here with these wills is that they contain a trust which stipulates what should happen to the 50% of the half share of the property and that person passes away. So on first death of partner A, the 50% share that they owned, passes via the will and is protected through trust law. And partner B, the surviving partner, retains their half share, retains the right, of course, to live there without complication, and can sell the property and buy new. And trustees of the new trust cannot force B out and need consent from B to do anything. So what happens finally then? So partner A's half share is held in trust, and the capital value passing to A and B's children when B finally dies. So in that way, we have protected the bloodline. It doesn't matter if somebody goes off and remarries, that is always protected. Okay, so in pictorial form, this is how this looks. So the family home, which is currently owned jointly, they then decide to create the tenants in common, so they each own 50% of the house. They then create new wills, which will mean that when they go, their retrospective share, 50%, passes through their will. And a trust is created within the will. And the little treasure chest there is just to hide the security or protection afforded by a trust. So that when one of them passes away, that 50% sits within the trust. And that's what creates the legacy. That provides a lifelong protection legacy for the bloodline. So solution for some and not all, again, this is not advice, this is just to illustrate a point. Tenants in common, a new will and a trust was right in this situation. Okay, so disinheriting your children, a really, really big question and concern that so many people, based on our experience, have currently. So a will alone is not enough to solve the problem if the assets are owned jointly. So it's a combination of things that we need to have a look at. So jointly owned assets and mirror wills, which pass everything to the survivor on first death and other beneficiaries on second death, are at risk of really common events. Divorce obviously is on the increase, and divorce, any inheritance passing through could be lost through divorce settlements, remarriage and cohabiting after the death of the spouse. Payment of care fees, again, average care fees vary throughout the country, but can be several thousands of pounds a week and can soon eat into someone's inheritance that they intended for beneficiaries. Taxman always wants his fair share, and there are a number of different taxes here that could reduce inheritance for children. Creditors or bankruptcy, we're seeing increasing levels of debt in certain sectors of society, and what we want to do is ensure that should those beneficiaries have those kind of issues, any hard-earned money being passed on to them isn't going to simply be lost by paying it to creditors. So some stats and facts now. So 1 in 4 people are prepared to mount a legal challenge against a loved one's will, and we are seeing an increasing amount of challenges. And what we want to do is help people plan in advance and prevent that situation from happening. The reason we're seeing that is because life is no longer simple, and complex relationships, and challenges brought about by second marriages and stepchildren, blended families, as we actually refer to it, mean that a lot of people are disappointed and disgruntled and feel that actually they're entitled to a proportion of the loved one's estate. And often people are relying on inheritance as a pension. So people are not shy about coming forward now. So please, please, please be aware of that. And we see, unfortunately, far too often, estate values being depleted or wiped out by unnecessary court and legal fees. So in the next 10 years, an estimated £376 billion should pass between baby boomers down to the next generation. And that's a lot of hard-earned money. And what we want to do is ensure that that money is passed to the people that you choose and doesn't end up in the hands of unintended people. So anybody that is thinking about protecting themselves and thinking about estate planning, a really good professional estate planner or solicitor should provide you with really robust documentation to protect against the legal challenge. So that would include reasons why and adequate measures and safeguards. So should something be challenged in the future, there is sufficient evidence there to prevent a successful claim. Lasting power of attorney. This is something I'm an avid campaigner of. I work directly with large groups to support and raise awareness about how important having a lasting power of attorney is. It's becoming increasingly popular, and with about 4,000 applications a day, I'm glad to see that the message is getting across. What it does is it provides 100% protection and great peace of mind for anyone that has an accident or becomes ill, either temporarily or on a long-term basis, permanently. So in that situation, you've appointed somebody or people in advance that you trust to look after your affairs if simply you can't. So property and finance is part one, and part two, health and welfare, and both are absolutely equally important. So please, if you're considering this, look at both of those parts. Both do very different things, but both absolutely equally valid. And I just want to highlight that the spouse, partner, children, no matter how old or how long you've known them, have no legal voice, have no legal rights at all. So they can't do anything for you at all, including operating bank accounts, speaking or have authority with the bank, building society, dealing with standing orders, direct debits, and of course making decisions that are life and death if somebody is on life support. It's giving control and authority to the people that you trust in advance through the health and welfare part. So they can make decisions on whether effectively somebody lives or dies rather than a stranger. This is all about keeping control of your affairs and decisions. Without a lasting power of attorney, assets can be frozen. So the British Banking Association make it very clear that banks are well within their rights to freeze access to accounts if somebody loses their faculties, mental faculties, because they become vulnerable, and of course they could become vulnerable to fraud. So banks will just want to prevent that situation from happening. So in that situation, it's not uncommon for people to be locked out of their own finances, meaning that often loved ones are having to put their hands in their pockets and settle bills personally for them until such time they can recover that through an alternative means, which is the court protection. So an LPA, lasting power of attorney, simply alleviates all of these problems. You're in control, you're nominating in advance who you trust to look after your affairs if you can't. So it's control, choice and peace of mind that affords you. So last year alone, the Office of Public Guardian, who regulate all of this, 2,000 lasting power of attorney applications because they were completed incorrectly. So again, a red flag here. DIY is really not recommended. These are really important legal documents and can have huge implications if they're completed incorrectly. And of course, unnecessary expense and delays and disruption if they're completed incorrectly. What are the options? Do nothing, hope for the best. Apply for a lasting power of attorney when you're well, or again, do nothing and leave it to your family if something happens and go to the court of protection. So these are 4 steps of arranging a lasting power of attorney. So John, 65, has 1 child, Sam, and he decides to go off and arrange a lasting power of attorney whilst he's well, put both parts in place and register it with the Office of the Public Guardian to make it legally binding and usable, so that when John has a heart attack and he's temporarily incapacitated, the son Sam is able to simply step in without disruption and look after his affairs for him. So it's a relatively inexpensive thing to do, and this is just a sample cost. This is just an idea. There is no downtime, and again, no cost for Sam. Doing nothing looks like, and the reason that I've highlighted all of these steps and points and kind of gone through all of this is to highlight the huge amounts of hurdles and hoops that families unfortunately have to go through if their loved one does unfortunately temporarily or permanently lose mental faculty or mental capacity. Loads of different steps, really expensive as well. So £770 in court fees, plus lots of other additional costs, non-negotiable, often family, because it's family that will have to make this application for the person. They will have to lay out those costs initially. So it's not uncommon for children, spouses, partners to put this on credit cards to cover the costs, potentially over £3,000 and beyond. Really expensive and really difficult route. No guarantee that the Court of Protection will award the deputy order, which is like a power of attorney, but with conditions. There's no guarantee they will award that to people that you choose. And it's highly common for them to reject a family application and appoint the deputy order to a local solicitor, who then will turn up frequently, so once a month, and decide how that money is actually spent, which is frustrating and upsetting and very expensive to the family. And of course, that deputy will be beholden to that person for life, and and is answerable to them. Completing annual returns and reports. It's very invasive, very time consuming and very avoidable. So please really seriously consider arranging a lasting power of attorney, which is very simple when you're well. Okay, so a little summary here. So an estate plan is like an insurance policy. We all insure our homes because it's a big, valuable and important asset. And estate planning is much like that. So it's about providing security in advance and planning and protecting yourself and the people that you leave behind to secure your future. And there are loads of ways that we can do this, and some of these are listed on the points. Huge amount of options with regard to wills, trusts, power of attorney, and that kind of thing. So really, really diverse. And if you have any doubts, and today has raised any questions, and you did want any further information, you can of course email in at info@eulogie.co.uk. Just going to look at funeral planning. I alluded to earlier on, really increasingly popular, common, and average cost of a funeral now £4,400. Who knows what that's going to be if it keeps going up by about 8% a year. So what we want to do is raise awareness and tell people that there are options. You can sort this out in advance, so they can be a great thing to do. If you are looking for advice on anything that we've gone through today, really important to check out the credentials of those people that will be providing advice. So please have a look for things like professional bodies. So are they part of these kind of bodies here, Society of Will Writers and the Society of Trust and Estate Practitioners, of which we are part of. So they are the gold standards, just for peace of mind and redress. We do provide an aftercare service. I've loved talking to you today, and of course, if you do have any questions and do want any further information, or do want to have a chat with me on a one-to-one basis, we can absolutely do that. Please email your name and a brief indication of what you want to discuss, and type in code 3 and email to info@eulogie.co.uk. Just here to say that we take your privacy very, very seriously, and we subscribe and comply with the General Data Protection Regulation. And in terms of how we hold information, the service is free of charge and without obligation. Thank you very much for listening. If you have any information, if you have any questions at all, please email into info@eulogie.co.uk. Back to Carla, thank you.
Thank you so much, Rebecca. And I'm sure I've seen in the chat box, at least, that I know there's at least 4 or 5 questions that they would like you to ask. But I'm going to pass to David as the manager of the chat box today to go through those. Your new title.
Thank you, Carla. Yes, there were questions posed and comments posed in the chat box, but also some came to me privately and I assure you they will remain confidential. One person had some concerns about that. Everything you've said to me is confidential. In themes then, I've divided it into the following. Number 1, what is your advice on setting up a trust for death in service benefit?
A really complicated area. So things like pension, death in service benefits, again, that's something we probably work directly with Neil Houchin, my colleague, who's done the webinars on the financial services side. So again, we'd look at nomination, so who are the intended beneficiaries. So it's just about ensuring that that then passes to the people that you choose, and you can do that through nomination.
Thank you. Do you have any money-saving advice for care home fees for self-funders?
Okay, this is a really hot topic. We get asked this frequently. People concerned about that. So absolutely, you do have options. We see a lot of DIY disasters in this area. There are ways to mitigate payment of care fees. They need to be done at the right time and in the right way. So there are vehicles that we can use to protect assets and protect property in that situation, but timing is critical. So depending on the person's situation, so what's their health, what's their age, are they in need of care, what's their personal financial situation. So once we know their personal situation, because that's the important message here, you know, we need to understand someone's own situation. If somebody is very old, in need of care and in poor and failing health, setting up a trust at that point is problematic, because the local authority potentially will deem that to be deliberate deprivation of assets. So really important, anyone that has those kind of inquiries, the bigger picture, the wider picture is absolutely critical. So we just need a little bit more information on the options that are available. And there are plenty of options. So just to reassure everyone, lots of options available.
Thank you. This is quite a philosophical point. In your professional opinion, why do you think so many people do not arrange a will? Do you think worry plays a part in this?
In my years of experience, people put it off. They certainly got it in their mind, and they're certainly reminded based on certain events in their life. And I think COVID has really brought that to the forefront of people's minds. I think people sort of don't like to think about it because maybe they associate it with dying. And also maybe they think it's complicated or expensive. And I just want to reassure people in that situation that, of course, none of those things are true. And we support people in going through that journey, and we make it as light as possible. And it's about control and choice, because none of us know when our expiry dates are, and none of us know what we're going to leave. And so that leaves a whole load of uncertainty. So we can make it simple for people. And I think that's the key message that I'd like to get across here. I've not met anybody yet that's spoken to me that at the end of the journey have said, you know, oh, this was, you know, not what I wanted. Everybody said, I feel completely reassured, I've got peace of mind, and I feel that, you know, a weight has been lifted from my shoulders. But I think there is a reluctance to probably think about wills, because people think, oh, if I make a will, does that mean I'm going to die? So there is the association with death. So I just want to reassure people, this is about really legacy. It's about thinking about what you've got that you've worked really hard for, and how can you protect that for people moving forward.
Thank you. And nice lead into the next one. If you have a straightforward will, do you need to get a solicitor involved?
No, absolutely not. You've got loads of options and choices. There's an enormous amount of people out there who are providing wills. I just really want to say a word of caution here. I've worked in this industry for so long. Free wills, there's free will months, there's all sorts of companies jumping on the bandwagon at the moment saying we're offering free wills to NHS workers, or, you know, various different sectors of the population. And I question what the content would be of those. So a good quality, modern, up-to-date will would generally be provided by a professional, and that's because of the complications that we've gone through today. So a standard basic will provides basic instructions on a simple set of circumstances. If there are complications with stepchildren, children from previous marriages, and other children, and different family dynamics, that's when we see the free will sort of come in and create complications, because they can't deal with those situations. So it's all about finding what's right for you. So probably writing down what your family tree looks like, what your estate looks like, and speaking to a number of people, doing some homework, doing some research, and checking out people's credentials. So who are they? Do they belong to professional bodies? Because this is a really big decision, and I think a lot of people place a lot of emphasis on, is it free or is it low cost? And sometimes that's not always great, and unfortunately we see the other side to that, whereby people either don't have a will because they've never got round to it, or they've gone for a freebie off the shelf at, I don't know, WH Smith's, or a free one online that's actually created more problems than it's solved. So it's just about what's right for your personal situation.
Thank you. If someone challenges a loved one's will and mounts a legal challenge, and if I would be disadvantaged if the challenge is successful, what can I do to protect myself?
Okay, so one thing I should say is we cannot block any kind of attempt to change a loved one's will. There is nothing that I'm aware of that we can do. What we can do is ensure that the quality of our documentation is absolutely perfect. You know, it really does represent a high standard. For example, dealing with the whys and having the information in the background. So excluded people, we see that a lot. So if somebody does, if they are excluded from an inheritance, how is that documented? Why are they being excluded? So we're providing a lot of background to that, and also capacity as well, mental capacity. People coming forward on the basis of mum or dad or brother or sister didn't really understand what they were signing. You know, the will was complicated, and so they're going for them on that basis. There's nothing that will block that, but what will prevent a successful challenge will be the quality of the will itself, and that's why we say for anyone that either has an old will or no will at all and is thinking about this, this is probably one of the most valuable things that you will ever do, because if you think about the document, yes, it's a piece of paper, but actually it encompasses everything you own. It's your property, it's, you know, legal guardian issues for children, it's security for generations. So I just want to stress, a will really now is no longer, you know, just a tick in a box. It's a really important step and shouldn't be taken lightly, actually. And again, just want to reassure people that a lot of people that are concerned about COVID, we've seen a lot of people rush to want to make wills and they've excluded, or they wanted to exclude people. You know, we're just there to sort of say, well, you know, take a breath and make sure we do this in the right way, because we are very aware of the number of challenges that are being brought about. And as I say, it's such a shame for people's wishes to be overturned because the will wasn't watertight enough.
Thank you. We have time for one last question here. Colleagues will be, we will get in touch with you if you've posted questions after. I have enduring power of attorney for my mother. Would you advise I change this to LPA? I probably don't have the 3 months to process this.
Sorry, can you just repeat the last bit, please, David?
I probably don't have the 3 months to process this.
Okay, so two parts to that question. Enduring power of attorney is the old style, so it was the precursor to the new system, lasting power of attorney. It still does the job. However, if you never lose capacity, it's never used. So the difference, that's the key difference between that and lasting. Lasting can be used right from the outset with the property and financial. So for anyone that just either can't get out or just has lost interest in doing things, and it's easier for kids to go on because everything's online these days, they can hop on and do that legally. So I personally always do recommend, in most cases, that somebody does upgrade an enduring power of attorney to a lasting, purely and simply because it's more sophisticated, there's more control. And of course, if you never lose capacity, the enduring never actually really gets used. So just to say on the second part of that question, registration with the Office of the Public Guardian typically takes 8 to 10 weeks. It is taking a bit longer at the moment, but there is something called a general or ordinary power of attorney, which is brilliant. And it means that you are protected immediately or now. So it doesn't need to be registered. So if there isn't time for whatever reason, I'm not sure why, for registration to take place, it is possible to have something which is immediate. So we're talking to a lot of people at the moment who want immediate protection, but are worried about this 8 to 10 or potentially longer timescale to register. We can look to set this up, and it means that the donor signs and every hour, there's no registration involved, and banks are happy to accept it. So as a short-term stopgap, immediate protection, a general power of attorney absolutely can be great for a lot of people.
Thank you, Rebecca. Thank you. Carla, you're on mute.
Thank you, David. Thank you, Rebecca. Thank you for everybody for attending today for a wellbeing lunch. We hope that it's been insightful. We've certainly received some good feedback already. What we would ask is, please remember you can contact Rebecca at the email address you can see on your screen, info@eulogie.co.uk. Please quote C3, just so Rebecca's got an idea of where these questions have stemmed from. If you would like to leave feedback about our webinar series, please email myself or David at agem www.od@nhs.net, and we'll be happy to do more webinars if we feel needed. But thank you for joining today, and have a lovely sunny afternoon.